So let's pick back up here and run through the rest of these slides about commission rules. So here's what you need to know about the commissioners themselves. First of all, when we talk about the real estate commission, we're actually talking about two different groups of people. You have the commission staff, the people that work for the real estate commission. Those are full-time employees. That's their job. There are 100 of them or more who work at the North Carolina Real Estate Commission. They are the people who enforce the rules. These are the people who make the rules. They are political appointees. They are appointed by the political leadership of the state. There are 9 members of the Real Estate Commission. It is a voluntary job. They are volunteers. That's what happens when you combine two words. They are volunteers who are appointed for 3-year terms. They can be reappointed. Some of them stay longer than 3 years. These are the current 9 members of the Real Estate Commission. You have to remember their names, dates of birth. I'm just kidding. You don't need to know. You don't need to know anything about them other than there are 9 of them. 7 of them are appointed by the governor and 1 each by the North Carolina Senate and House of Representatives. And if you'd like to meet any of the 9, you are free to attend a real estate commission meeting. They meet once a month, generally the 2nd Wednesday of the month. I believe the meeting is this week. If you'd ever like to meet any of those 9 people, and those meetings are open to the public. These people come from around the state, and they are mostly real estate brokers, but there are always at least 2 of them who cannot be affiliated with real estate in any way. There are always at least 2 members who are in no way affiliated with real estate at all. And the 2 that are currently members that are not affiliated with real estate are right here and right here. The rest of them are real estate brokers or closing attorneys or appraisers or have some affiliation with the real estate industry. Okay? Those are the people who make the rules. They vote on the rules. They make them. The staff enforces them. You will probably never deal with these 9 people, by the way. If you deal with these 9 people, it's probably not a good day. Just FYI, unless you just show up to a meeting and meet them. They're super nice people. But if you're ever dealing with them in an official capacity, it probably means you're having a bad day. The only 2 reasons I could think of that you would ever deal with these 9 people in an official capacity as a licensee is, number 1, when you apply for your license, you have some sort of a character or background issue that comes up on your background check, and you have to talk to them in a character conference before they'll issue your license. That would be one reason. Or you are in front of them for a disciplinary hearing, which would be another bad reason to meet one of these people. So you probably will never encounter them. Several of them are good friends of mine, but don't call me if you end up in front of them. I don't want to. All right. So what can they do? What can those 9 people do? And when we talk about disciplinary action, it is always up to the members of the Real Estate Commission. The staff cannot discipline you. They cannot do anything to you. They can recommend discipline. So when a complaint is filed, it's members of the staff that investigate the complaint, and they make recommendations to the commission, but there's always a hearing, and the commissioners decide ultimately what would happen to you. What they can do, they can reprimand you, they can suspend your license, they can revoke your license. What they cannot do is fine you. That's a big one on a test. The Real Estate Commission does not have the power to fine licensees. The only fine that can be issued by the Real Estate Commission is for who? Timeshare developers. Exactly. And what is that fine? $500 per violation with no maximum amount. Good. So there are lots of things that we cannot do as licensees. Obviously, we can't violate any commission rules. The second one is an important one that brokers get in trouble a lot with. We are not allowed to draft legal documents. So basically, what can we do on sales contracts, which we're about to talk about, by the way. Sales contracts is going to be our next topic. What are we allowed to do? Fill in the blanks. That's exactly right. We're allowed to fill in the blanks on pre-printed forms. What we are never allowed to do is draft contract language. Can the client draft it themselves and write it in on a contract? They can. It's their contract. We cannot draft it for them. We can't even write in what they tell us to write in. If they want to draft language, you hand them a pencil, a pen, and let them go for it. But don't do it for them. Self-dealing, that's another thing that we're highly cautioned against. Self-dealing is basically putting yourself ahead of your client's interest. I'll give you an example of what the Real Estate Commission would consider self-dealing. If I went to a listing presentation and I was trying to list a property for sale, and once I got in there and I started walking around the home, I decided, I really like to make an offer on this myself. What should I do at that point in time? Well, obviously they know I'm a broker because I'm there doing a listing presentation. What should I do with that seller at that point in time? Tell them I'm interested in the property. I shouldn't continue this conversation about listing their property because what might they be telling me? Personal information that could hurt them in the transaction. So I have an obligation at that point to say, you know what, I can't really talk to you about listing your house because I'm actually interested in buying it myself. That's what they mean when they say don't self-deal. Don't put yourself ahead of your clients. And this last one should be self-explanatory. I wish we didn't have to have a rule about it, but we do because clearly somebody tried to do it. You can't be a buyer's agent on a property where you are the seller. Think about that for a second. If I'm selling my house and a buyer comes and they're interested in making an offer, should I offer to represent that buyer? No. Hello? You can't possibly represent a buyer against yourself. You can't do that. Somebody said, oh, sure I can as a dual agent. No. No. It doesn't work that way. So you may not represent the buyer if you have an ownership interest in the property as a residential broker. You just cannot do it. Okay? And then, of course, misrepresentation or omission, which we've already talked about. You cannot do that. And make sure, I gave you the page numbers here. Page 618 through page 621, they have several examples of misrepresentation and omission. So if you struggle with those at all, then that would be a good place to go look at the examples they've given you for misrepresentation and omission. You can read through them. They're pretty long, but it gives you an idea of what the Real Estate Commission looks for with misrepresentation and omission. So education rules. This is where we start to get in some dates that you need to pay attention to. Basically, when we talk about active status, again, it means you can get paid. That's the most important thing that it means. But it also means you've done everything right. When somebody's on active status, they've taken all the education they were supposed to take, they've paid their renewal fee, they've done everything. So, what are the things that need to be done? Everybody must take continuing education. Continuing education is not just for provisional brokers. It's for all real estate brokers. Everybody must take continuing education. 8 hours. You need to know how many hours. So CE is 8 hours. Here's the way I remember that. I know it's silly. Might not help. Might. CE is short. There's really no abbreviation for post-licensing. I just have to say post-licensing. So I think CE short, it's 8 hours. Post-licensing, it's a long name, 30 hours. That was my mental trick years ago to remember it. Okay? But CE is 8 hours and it has to be taken by everybody and you need to know the deadline for it. Remember with post-licensing the deadline was what? Your license anniversary date. So that means it's a different deadline for everybody based on when you get your license. CE is the same deadline for everybody. It is June 10th. The CE deadline for everybody is June 10th, which means my life is chaos in the months of April and May because everybody waits until the end to take it. Okay, so June 10th every year is the CE deadline. And you must have taken 8 hours of continuing education by June 10th in order to remain on what status? Active status. If you don't take your CE by June 10th, what's going to happen to your license? It would fall to inactive status. And you could not practice real estate at that point in time until you fix that deficiency. Also, everybody must renew their license by June 30th of every year. June 30th is the renewal deadline. Renewal is paying a renewal fee, and that fee is currently $45. So you got to pay $45 by June 30th of every year. Now, you need to know the verbiage that goes along with not paying your renewal fee. This is not inactive. Pay attention. You might see this on a test because they know you don't know this word. Think of an old-fashioned parking meter. If you don't put money in it, a little red flag popped up. And what did it say on that red flag? Expired, because you didn't put money in the machine. Think of the real estate commission as a parking meter. If you don't put money in the machine, your license status is going to be what? Expired. The renewal fee is not paid by June 30th. Your license status is expired. Not inactive. Expired. Expired is far worse than inactive. Because if you go expired, you can actually lose your license. You can never lose your license for being inactive. So, can you lose your license for not taking CE? No. Because you go to inactive status. Can you lose your license for not taking post-licensing? No, because you go inactive. Can you lose your license for not paying the renewal fee? Yes, you absolutely can. You cannot. I wish you could. I wish you could, because I would. Now, they open it up mid-May, and you have from mid-May till the end of June to pay it every year. And if you have a firm license, guess what? You got to renew that one too. That's exactly right. By what date? June 30th. Good. The dates are important. You'll see them on the test. Okay? Reporting things to the commission. You have 10 days to report a change of address. 10 days to tell them you moved. You have 60 days to tell them you murdered somebody in a back alley somewhere. I don't know why, but that's what the rule is. 10 days to report a change of address, and you have 60 days after the final judgment, so you don't even have to tell them you've been charged with murder. You just have to tell them after you've been convicted. I presume that would be the least of your concerns if you had actually been convicted, but you do have 60 days. So, for example, if you were convicted of something like a DUI, you would have 60 days after the conviction to report that to the real estate commission. Okay, so anything that any criminal conviction whatsoever, 60 days. Any change of address, you have 10 days.
Would that be a problem, DUI?
DUI is a problem, yes. Are you going to lose your license because of a DUI? Generally speaking, I can't speak for the commission, but I highly doubt it. But they would most likely take some disciplinary action as a result of it. Primarily, they'd probably say you couldn't have clients in your car for a certain amount of time.
How about in the past when I got them 3 years, 4 years?
They will certainly want an explanation, and they may require a character conference because of it. It's not going to prevent you from getting a license. Again, in my estimation, that's an estimation on my part based on what I've seen in the past. But they will want to talk to you about it, most likely. And they will not talk for any, people say, well, what do I have to explain to them? Anything. When you do that background check, even careless and reckless driving, speeding, you have to explain it to them. Nothing goes past their notice. That doesn't mean they're not going to give you a license because speeding shows up on your background check. It simply means you have to explain it to them. With something like a DUI, they do look at how long in the past it's been, but they do look at those more stringently because obviously they understand there's a high chance of you putting clients in a car with you. And so they may or may not request a character conference. You won't know until you've passed the exam because they don't even look at your background check until you've passed the exam. They used to do that first, but what they found was that it was a waste of their time because a certain percentage of people never pass the exam. So now they wait until after you do the application, you take the exam. Once you've passed the state license exam, then they'll notify you whether or not you have to come for a character conference. And when you come for a character conference, you sit down with usually 2 or 3 of those 9 people, And they talk it over with you and make sure that they feel comfortable that whatever the issue was, it's in your past, and then they'll make a recommendation to the full commission and they take a vote of yay or nay whether to issue your license. So, and you can attend all those hearings. I go fairly often. You see some interesting things on those cases. I mean, you know, the last time I went, there was one applicant who had 2 convictions for prostitution that were, you know, fairly long while ago, but you know, they're there, and they have to discuss it and vote on it. There's no names, don't worry. They're just case numbers when they're there, but they will want an explanation for anything that shows up on that background check. Okay? Don't stress out about it, please. If it's well within your past, they are very understanding of that, in my experience. Advertising, record keeping. First of all, we have to keep all records for 3 years. All records. In this environment, that is a scary rule. If I post on Facebook that I'm holding an open house this weekend, that's a record, according to commission rules. Any advertisement I do for brokerage service is a record. Any paperwork we fill out, any post-it notes I write down, any text messages with my clients, those are deemed real estate records, and we have to keep those for 3 years. So if you're going to conduct business via text message, then you need to look into an app that will save and keep, so you can download, archive those text messages, because you'll need them if you're ever asked for them. So just FYI, once you are licensed, any contact you have with clients or about clients, you need to keep those records for 3 years after the end of the transaction. Now, if you do something like property management, the transaction hasn't ended. So if I've been managing the same property for the last 7 years, how many years worth of record keeping do I have to have for that property? All 7. Because I have to keep the records until 3 years after I've stopped working with that transaction. So as a property manager, say I manage a property for 7 years and then they move to another property management company. I have to keep all 7 years worth of those records until I've not worked on that property for a period of 3 years. So there's got to be a 3-year dead period cut off from when you stop working with somebody till you can get rid of the records. So you need good record keeping. This one, a blind ad. You're going to see this on a test. They want to know, can you recognize what is a blind ad? Because we have a rule against blind ads. The Real Estate Commission says that any advertising must include one of 2 things. It must either identify that the ad's been placed by a real estate broker. Broker means non-provisional in this instance. So either that it's been placed by a real estate broker. So how would you identify that it's been placed by a real estate broker? You would put what behind the person's name? Broker. You can't just say Travis Everett, because the public doesn't know that Travis Everett is a real estate broker. So it would have to say, contact Travis Everett, broker. Or it has to have the firm's name. It doesn't have to have both, but it has to have one or the other. Okay? But make sure when you say it has to have the broker's name that you understand that means the word broker appears behind the name. So for example, same property, 148 Main Street, 3-bedroom, 3-bath, 1,850 square feet. Call Bob Kastner, comma, broker at 919, blah, blah, blah. That's an allowable ad because it's clearly identified that the ad's been placed by a broker. Whereas the second one is not allowable. Because when you read the second one, who is Bob? We don't know. It could be the owner. It could be the best friend of the owner. It could be a real estate broker. Be anybody. And that's why it's called a blind ad, because you don't know who you're calling. If you looked at that ad, you would not know who had placed it. Does everybody understand the difference between ad number 1 and ad number 2 here? Okay. We could also, we could have 148. The second one could be legal if it said call Bob at United Real Estate of Raleigh. Because it doesn't have to identify the broker's name and the firm, it's one or the other. So it's fine to say call Bob as long as you say at and you put the firm name. That would be okay. It just has to be clear that the ad's been placed by a real estate broker or a real estate firm. Okay? Make sure you're good with that. And who would be responsible for approving these ads? The BIC. The BIC. Absolutely. Oh, just let me ask you a question here. Remember when we said the BIC was responsible for all advertising? What was the first example of advertising I gave you there? Business cards. So, remember those full brokers we talked about earlier that we said could be active even though they didn't have a BIC? And Mahogany was asking all, can they do this? Can they do that? Remember those questions right there? What can they not even have if they don't have a BIC? A business card. Can't even have a business card without a BIC because that's advertising. And the only person that's allowed to approve advertising in this state is your broker in charge. So it's really very limited what they can do without having a BIC. All right? Disclosure of compensation. We must disclose all of our compensation in writing no later than the time of offer. Always. Every penny that we're going to be paid in the transaction must be disclosed no later than the time of offer, and it must be disclosed in writing. However, never in a sales contract. That is not where we put anything about our commissions. As a matter of fact, the Real Estate Commission has a rule, which we're going to talk about later today, about pre-printed sales contracts that says you can't have any statement at all about commissions or broker liability in a sales contract. What do we mean when we say broker liability? What would we try to stick in a contract maybe? What do you think? Oh, there you go, right? We would love to stick in a contract. I'm not responsible. I don't care how bad y'all muck this up. It's not my fault, right? I am not responsible. Don't sue me. I can't put that in there. It cannot be in a pre-printed sales contract, and nor can any statement about my commission. I can't put in. Here's what we don't want. We don't want real estate brokers presenting offers that say, our offer is conditional on the seller paying us a 5% commission. You can't do that. So when you get on a test, should you disclose your commission to buyers? Should you tell them everything you're being paid? Bonuses, trips, iPads, everything. And should you do it in writing? Should you do it in writing on a sales contract? No. Anywhere else? That's a good question. Sarah's question is, and I'm not trying to even give a smart answer, but literally anywhere else is fine. The Real Estate Commission doesn't say you have to do it this way. Now, the most obvious place is like on your buyer agency agreement or your listing agreement. That's a very obvious place because commission is specifically mentioned on those places. But you could do it in an email. One of the things I always like to do when I show houses, for example, is give the buyer the agent-only copy of the MLS printout. I don't even know why we have an agent-only copy. It's the dumbest thing I've ever heard of. Because what are we supposed to tell our buyer clients in transactions? Everything, right? Everything we know. Why would we have a version of the MLS sheet that's only for us? And guess what? What do you think most agents put in the agent-only copy? All the crap we're supposed to tell our clients. The HVAC doesn't work. Well, why you put that in an agent-only version? What am I supposed to do with that information? To tell it to the buyer. So you know what I give the buyer to cover myself? I give them the agent-only version. I dare somebody from the MLS to tell me I can't do that. Please, bring it. You on YouTube? Bring it. Right? They are owed that information. And guess what else is right on the bottom of it, right down there? Commission. How much compensation that they're offering to pay in the transaction. So by doing that, I'm disclosing in writing to my buyer, and I actually show them, right? The first one when I give it to them, after I show them the house, well, here's what I do. I always give them a copy of the listing sheets as well. and I don't give them the buyer version. I give them the listing agent version. I give them the same one I've got, and I show them where all the information is on there. I actually circle for them. Here's the compensation down here in the bottom. Here is where they put the living area. Here's where they put the agent-only notes, the stuff they think only I should see, but I want you to know it. You know, you can really build some trust with your client if you say stuff like that to them, right? And so I give it to them, and every time I show them a property, I'm giving them the same copy I've got, so they know I'm not trying to hide anything from them. And so that would cover it. You know, any way you want to do it in writing is good. Yes, Mahogany. Listing agreement. So I want you to separate in your mind. The sales contract and the listing agreement are two different things, right? Who's the sales contract between? What are the two parties in the sales contract? Buyer and the seller. Who are the two parties in the listing agreement? Firm and the seller, right? Or buyer agency agreement would be firm and buyer. So in the contract between the buyer and the seller, there should be no mention whatsoever of commission, right? But in the contracts between the firms and the clients, that's absolutely the place to mention commissions. Does that help? Good. Good. Yes?
Does it list out your expected commission regardless of what you're going to get paid in the split? Like I remember you saying you
So
would
on
get an extra 5% or, you know, 0.5% or whatever.
Emily's question there is basically, you know, on the buyer agency agreement, what am I stating on there as far as commission goes? What you're stating is what you expect to be paid by the buyer if the seller doesn't pay you that amount. So what you're essentially, on a buyer agency agreement, what you're putting on the form is, this is what I expect to be paid. And I will seek this compensation from the other side of the transaction first, but if they're not willing to compensate me at least this amount, then you, as my client, will pay the difference between whatever they do pay me and whatever this amount is. So if I put 2.5% on my buyer agency agreement, and then the seller is paying 2.4%, presumably I could hold the buyer responsible for the difference between those two. Does that make sense? Well, only one's going to be on the buyer agency agreement, but then if I give them the printout from the showing, it'll have the other that's there. That's exactly right. What they're offering. Yeah, yeah. Whatever they're offering is going to be on the listing sheet. And then they've got a buyer agency agreement, which of course says what I expect to be paid. And then, you know, it's up to me whether I want to enforce them paying the difference. I've had agents all the time say, well, I wrote 3% on there, but I would never charge them anything. I said, well, then why did you write 3% on there? Because the number you write on the buyer agency agreement shouldn't be what you expect to get paid. It should be what you intend to charge the buyer if the seller won't pay you. Does that make sense? Because the number you write on the buyer agency agreement has no impact whatsoever on what you're actually paid unless you're charging the buyer. Because if you're going to accept whatever the seller pays and be fine with that, and you absolutely swear you're never going to charge the buyer anything, then what should you put on that line for fee? Zero. If that's what you absolutely plan to, and I've had people say, I would never charge the buyer anything. I said, okay, we'll put 0 on the line. Well, I would never work for 0. Well, those two statements can't be true at the same time, right? Because if the buyer wants to look at something where the compensation offered is 0, you have to show it to them. You would just have to make them aware, hey, now's your time to pay. Does that follow for everybody? So what the number you should write on the buyer agency agreement is what you expect them to pay you. Okay? Handling trust money. So what is a trust account? What is a trust account? It's an account where I hold money that doesn't belong to me. Specifically, who does it belong to? My clients. In most cases, this is money that belongs at least partially, to my client. It may not fully belong to them, because if I represent the seller, if I'm the listing firm, and I'm holding an earnest money deposit, does that money belong to the seller? And it also belongs to who? The buyer. That's the whole point of holding it in a trust account, folks. It belongs to them equally. And if you think of it that way, that'll help you answer all the questions related to how you can release it. Because if the money belongs to both the buyer and the seller, then whose permission do you need to release that money? Both the buyer and the seller. That's the whole point of holding it in trust. It doesn't belong. If it belonged all to the seller, guess who we would give it to? The seller. There wouldn't be any need for a trust account. If it belonged all to the buyer, we'd give it to the buyer. There wouldn't be any need for that. You pass that back to Dennis, please. Okay? So, trust accounts. Anytime we're handling money that belongs to somebody other than ourselves, then generally speaking, it needs to go in a trust account. Examples would be earnest money deposits, tenant security deposit, rent, HOA dues if we're managing a homeowners association. All those would go into a trust account. So if we are a property manager, are we going to have a trust account? Pretty much, yeah. Because look at, as a property manager, what's your number one job? Collect what? Rent. And if I'm collecting rent, where does it say it has to go? Into the trust account. So let me ask you this question. Can I collect a rent check made payable to the owner of the property and hand it directly to the owner of the property? Can I? Where does it say money has to go? In a trust account. So can I collect a rent payment made payable to the owner of the property? No. Where's the rent going to be made payable to? My trust account. How's the owner of the property going to get paid their rent? From me. Not from the tenant. From me. Because it has to go into my trust account if I'm collecting it. It's the way this works. I don't get to collect money for other people. I collect money into my trust account and then I disperse it accordingly. Does that make sense for everybody? Tenant security deposits. Who would they be made payable to? My trust account. That's exactly right. Earnest money deposits. Who would they be made payable to? My trust account. Okay? It's got to be a separate account. We have a special word for it when we mix our money and their money. It's called commingling. Commingling is bad no matter how it happens, folks. Some people think, oh, there's too much money in the trust account, that's not a big deal. Wrong. Any imbalance in a trust account is a big deal. A shortage is a big deal, and overage is a big deal, because either one of them represents commingling. Commingling is any time the trust account is out of balance, and it should never be out of balance. Do I have to have a separate trust account for each transaction? Mm-mm. Do I have to have a separate trust account for tenant security deposits and rent and tenants and earnest money deposits? And do I need separate accounts for all that? Nope. I can have one. I can have one. It's up to me how many different sources of funds I want to have in that one account and how I want to manage it. That is all up to me as the manager of the trust account. Now, I am allowed to keep some of my own money in that trust account. Up to how much? $100. The reason for that is bank fees. Think about it. How many of you, I know I'm asking a question that doesn't exist anymore. How many of you still have a checkbook? Like, how many of you have paper checks, right? Isn't that a shockingly low number of people? Look around the room. They're like, what is that? I don't know what that is, you know. Paper checks. Well, if you have a trust account, you're going to have them. When you need to order checks, and you tell the person at the bank, I need checks, what do they, those of you that have them, what do? They take the money out of what? Out of the account. Here's the problem with a trust account. That's not your money. This is not the rule. It used to drive me crazy. The rule was you couldn't have any of your own money in the trust account. And of course you can't spend your client's money. So you go to the bank, you say, I need checks. Okay, Mr. Everett, we'll send them to you. Well, I need to pay you for them. How much are they? Well, we'll just deduct it from your account. You can't deduct it from my account. I need to pay you for them. How much? Well, we deduct it from the account. So if you want to make a deposit in your account, I can't make a deposit in that account either. Right? Because if I'm making a deposit, it's my money, right? If you're taking money out, it's somebody else's money. And so we finally got this rule changed. You know how we finally got it changed? We all started reporting to the Real Estate Commission a trust account violation every single time the banks charged us money. Because that's what the rule required us to do. And they finally said, Uncle, we give. Okay. You can keep $100 in there. So that's why the $100 rule. You can keep up to $100 of your own money in the account to cover those banking fees and that sort of thing. Can it be interest bearing? There's an interesting question for you. It can. It can. It can be an interest-bearing account. That's exactly right. We have to have it in an FDIC-insured bank. It has to be a bank. I got it. It has to be a bank. I think I got it. There we go. Has to be a bank, and it has to have FDIC insurance. The reason for that rule is this. FDIC insurance covers $250,000 in deposits for any depositor, right? If the bank were to go bust, if the bank went bankrupt and didn't have any money, the Federal Deposit Insurance Corporation would cover up to $250,000, but it's actually much better than that. This is why everything has to be labeled trust account. We say everything must be clearly labeled trust account, and here's why. If Tasha has an account at the bank, up to $250,000 of her deposit is insured. That means if the bank went completely bankrupt and didn't have any money, who would give her her money? FDIC would give her her money, as long as she didn't have more than what in her account? 250. You have more than $250,000 in your account? You're in good hands. All right? You're covered. Could a trust account have more than $250,000 in it? Yes. Here's what the FDIC says about trust accounts as long as they're clearly labeled trust account. Each individual client is covered up to $250,000. So if I have 100 different clients' money in my trust account, every single individual client would get that $250,000. So I could have millions of dollars in my trust account and it'd all be fully insured, because each individual client would be covered up to $250,000. But that only happens if everything associated with that account is clearly labeled trust account. So does the statement have to say trust account? Yeah. How about the deposit slips and the checks? Everything has to be clearly labeled trust account, and that's the reason why for that FDIC insurance. Okay? We don't have to have trust accounts. However, on a test, if you're asked for the most common place for an earnest money to be held, it's still going to be the listing firm's trust account. That's the answer they're looking for on the test. Slowly but surely we're moving away from that in the real world, but on a test they still like to see that as the answer, that the listing firm would be the most likely place to hold an earnest money deposit. We're slowly working toward the point where the closing attorneys are holding them most often. Like, for example, personally, my firm does not maintain a trust account any longer. We simply have the closing attorneys hold the earnest money deposits, which gets me out of that business.
Is an escrow account a type of trust account, or is it just?
Escrow and trust mean the exact same thing. Exact same thing. Good question. Okay? The funds can be dispersed either at closing or when both parties agree. Never do you disperse money from a trust account without the permission of both parties. For example, when we get into the sales contract, we're going to read language where it says under certain situation, if the buyer breaches the contract, the earnest money deposit shall be forfeited to the seller. That's what the contract says. Earnest money forfeited to the seller. So, buyer breaches. You're holding the earnest money. What do you do with it? What do you think? Say, I hear wait, I hear get permission, and those are the good answers. Here's what you don't do. You don't give it to the seller. Even though that clear language, that's what the contract says. Who is that language for? Not only attorneys, but go one step up the ladder. A judge, a court of law. We don't disperse the money unless both the buyer and the seller agree to disperse the money. Okay? You don't disperse disputed funds. Even with things like tenant security deposits, you don't disperse until the tenant's vacated the property. So like for the tenant security deposit, do you think you can take unpaid rent out of a tenant security deposit? Is that something that you can use the security deposit for if the tenant doesn't pay rent? You think that's an allowable use? You don't think so? You don't think I could take money out of a tenant security deposit if they don't pay the rent? I mean, what do you think a tenant security deposit's for? Why do it was for damages, true, but what else other than damages? Unpaid rent, court costs, all those things we can charge against the tenant security deposit. That's why we hold a security deposit. But we can't charge it as long as the tenant's still in the property. We can't touch it until the tenant's vacated the property. Because the tenant vacating the property is their permission for you to reconcile their tenant security deposit. So we always need the permission of both parties to touch these monies that we hold in our trust accounts. Okay? Trust funds must be deposited no later than 3 banking days after they're received and we're under contract. It has to be both. Now notice this rule is no later than. Does it say when you can deposit it? Does it? So can I deposit it earlier than 3 days? Can I deposit it as early as I want to? Absolutely. So and here's what I mean by that question. I have a listing. Somebody brings me an offer. They have their earnest money deposit check paperclip to the offer. My seller has not yet accepted the contract. We're still negotiating. Can I deposit that check? Can I? Does it say anything about I can't do it before this happens? So can I deposit the check? No, that is not what that rule says. The rule says no later than. It doesn't say anything about earlier than. If somebody hands me a check, folks, I can deposit it. Period. End of discussion. That's not what this rule is about. We're getting into contracts here. You have to learn to pay attention to phrases like no later than. No later than does not mean no sooner than. Right? No later than means you can't do it past this date. But it doesn't mean there's a starting point. Can I deposit that check anytime I want to? Absolutely. Even without a contract. Because it doesn't say anything about when I can't deposit it other than no later than.
So you can deposit it, but would you or should you without the seller's?
Why wouldn't you? Because what happens if you lose the check?
That's why some people would want to deposit it, because then I don't have to worry about what? Losing it. Some people would say, I don't want to deposit it because I don't want to do the paperwork if what? If the seller doesn't even accept the contract, then I've got to refund the earnest money deposit. Does that make sense? But here's what I want you to understand. We're getting in the part of the class where one turn of a word means everything. No later than means no later than. It doesn't say no sooner than. So the answer to can we deposit that check is a resounding what? Yes. If I'm taking applications for a property that I have for rent and I get 15 applications and my rule is you should attach your earnest money deposit and your tenant security deposit and your first month's rent with the application, can I deposit every single one of those checks while I'm evaluating those tenants? Yes. Absolutely. I'm not saying I would, I'm not saying I should or I shouldn't, I'm saying I could. What you need to understand about this rule is it only applies to I can't do it any later than 3 days after I've received it and I'm under contract. So here's what that does mean. That check comes in, paperclip to the offer, earnest money deposit. I got the offer 5 days ago. Check is still paperclip to the offer. Have I violated the rule? Not necessarily. Because it's no later than 3 days after we have the check and we're what? Under contract. So just because the offer came in 5 days ago, do I necessarily have a trust account violation if I haven't deposited the check? We'd have to look to see when we also went what? Under contract. You have got to pay attention to the language. I mean, this is where it gets nitpicky. I'm dragging you through this for a specific reason because, folks, if you can't read that and you can't understand that, you're going to have a hard time passing the test because that's exactly the kind of turn of language they give you. All right? So, when would it be a violation? When 3 days had passed since what? And you had the money in hand. Because could I be under contract for 3 days and not even have the money yet? Right? The key here is it's 3 days from the time I've received it, and both of those things are true. So if I get the check in with the offer, and 3 days later my client accepts the offer, when does my 3-day clock start to tick? Once they accept. How about if I get the offer and it doesn't have the check with it, and my client accepts the offer? When's my 3 day going to start to tick? When I get the check. It's when all of it has happened that the 3-day clock starts to tick. Does any of that have anything to do with when I could deposit it, as far as how early I could deposit it? No, I can deposit it as early as I want to. As soon as I get the check, I can deposit it.
That's what I'm confused.
No, you're fine. I want you to ask.
You can deposit it without the contract.
Absolutely.
But it says in the contract.
No later than. No later than those things happening. In other words, don't do it after these things have happened. You can always do it before.
The contract has been formed, start ticking when that
Communication of acceptance. That's exactly right. That's exactly right. So here's the way to look at that rule. You're always going to have 3 days. At least 3 days. Because no matter whether you get the check first or you get the contract first, the clock doesn't start to tick until you got what? Both, the check and the contract. So you're always going to have 3 days notice, worst case scenario, to get this stuff deposited. But you can always do it sooner. As soon as the check hits your hand, if it's made out to your trust account, you are free to deposit it. Now, if I were you, I wouldn't do that without informing the other party because they may not be expecting you to deposit it. I mean, you would think you shouldn't write a check that's not any good, but people may think, well, I'll move the money over if the contract gets accepted. If you're going to deposit it as soon as they hand it to you, just be nice of you to inform them that that's what you plan to do. Okay? As provisional brokers, you don't get 3 days. As provisional brokers, you turn it over immediately. All right? And the last slide you've got here for commission rules. As a non-provisional broker, you can do something called a BPO, a broker price opinion. Now, what did I say? As a what kind of broker? Non-provisional. As a non-provisional broker. So that means this rule doesn't apply if you are a provisional broker. As a non-provisional broker, you can do a broker price opinion. A broker price opinion is just a CMA. It's a market analysis. The difference is you're charging a fee for it. You're charging them a fee. And they're not your client. This is not a seller you're going to represent. This is not a buyer you're going to represent. This is just somebody who wants to know, hey, what is that house worth? Most often, that's going to be somebody like a bank. Maybe the bank is considering foreclosing on the property and they want to know a value of it, for example. But somebody has called you and said, Gray, I want to know what that house is worth. And that's the only thing they want to know. They don't want you to sell it. They don't want you to represent them as a buyer. They just want to know what that property is worth and they want to pay you a fee for it. That is called a broker price opinion. You can only do that if you're non-provisional. PBs cannot do these, okay? And the magic language you need to know is if you're going to do a broker price opinion, you always have to use that language: probable selling price, probable lease price. It has to use that specific language. This is the probable sales price. This is the probable lease price. Okay? Everybody good with those? The big key is they can't be done by who? Provisional brokers. Good. That is it for license law stuff.